Hello, hello, friends. Welcome, welcome. I've been away for too long. My name is Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. You remember. Wow. I probably say this every time, but this is just an incredible, humbling, and for me, these humbling moments are few and far between, as Morris will attest. So it truly is humbling to be with this incredible, as I build it, all-star EB-5 industry panel. I mean, my gosh, who are the stars? Grau, Executive Director of IIUSA, he's right there. David Morris, Chair of AILA EB-5 National Committee, got him. Steve Strnisha, CEO of Cleveland International Fund, boom, I see you. Ms. Lulu Gordon, General Counsel of EB-5 Capital, and my dear co-chair of IIUSA's Public Policy Committee. Behring Regional Center. Who doesn't know Behring? Well, we got Greg Sheehan, who is, I don't know what his title is, incredibly august and very important. It has to do with compliance and knowing all about USCIS and their fabulous investor platform. So he'll tell us his actual title. And Suzanne Lazicki, who doesn't know Suzanne and her incredible blog that we all turn to for the latest and the best in EB-5 industry analysis and what's up in our world. So thank you to all of you for saying yes to joining me this afternoon. So our topic today is kind of unpacking the last USCIS EB-5 stakeholder engagement. As you all know, it was held April 25th, not too long ago. And it was a postponed engagement that was originally scheduled for March 20th. So just to kind of set it all up, right? Late January, we got an announcement that USCIS was holding another stakeholder engagement, then set for March 20th. And it was going to cover 3 specific topics. The Form 956K, the new form that promoters are required to complete, regional center operations, and the sustainment requirement. And it was going to be a supersized engagement, 90 minutes. Wow. And folks were invited to submit comments. And of course, IIUSA did. We submitted our comments, February 10th or 11th or sometime right before the deadline. And we can talk about the contents of that, of those comments. And of course, AILA EB-5 committee did as well. So we were anticipating, what was going to happen at this stakeholder engagement, what would be said, what would be announced, and then of course there would be a Q&A as usual. And these are big topics: regional center operations, the new form for promoters, and sustainment requirement, right? I mean, the big question is, do we really mean that the investment requirement is 2 years? Doesn't have to be longer than that. So these are really big questions. And then we got another email in our inboxes that said this weighty engagement was postponed to April 25th from March 20th. And I think we're getting some insider scoop that the service just needed more time to know what it was going to say, to prepare for these weighty topics very well. So we all tuned in as we must, and so I guess I want to start with that, just sort of opening up the floor a little bit. What did we think? I mean, what did we hope for going into this? And I ask that question because it seems nearly universal every time that there is a stakeholder engagement, and this has been for years. folks seem to sort of roll their eyes and go, oh, and I'm sort of kind of quoting, and it's going to be a waste of time. We're not going to learn anything. There are going to be people dialing in who don't know anything about the program. It's just this sort of like, collective groaning and eye rolling thing happening. Now, that hasn't been my reaction to these things, but that's sort of what it seems like generally. Now, was that your reaction? I'm just going to go around. I mean, what was your feeling going into this? What were your expectations, Suzanne?
Because when they postponed the engagement, they said that we're postponing it because we're very carefully reviewing the comments that we received and we want time to respond to that. Yeah. I was hoping that there would be some response to the comments that we submitted in advance on investment amount and regional center operations, and particularly with respect to regional center operations, just because it is a very urgent question about what's the status of investors whose regional centers aren't planning to move forward, and for the regional centers, how do we comply with the integrity fund and so on. So at the same time, having listened to stakeholder meetings since 2010, I shouldn't have been optimistic that they would possibly have very much to say, especially in a stakeholder meeting context in response to our comments. So I guess on reflection, I'm not that surprised, even though immediately after the meeting, I was not happy.
Ms. Lulu, what were your hopes and expectations?
Well, I'm an optimist as well, so I expected answers. That's what I expected. Answers to some very important questions that we have teed up for them over and over. So I don't think the questions, of what needs to be answered are at issue anymore. And, the idea that they would postpone in order to think about the comments and that they got that's a good thing. I'm thrilled to hear that. I just feel like it's a glacial pace at which they make up their minds about stuff. And I will bring this up just because it's apropos to what you asked on this quarterly settlement meeting call. The fellow from the Department of Justice said, well, we finally do say what we think, like about the integrity fees, and we immediately get sued, as if that would be a reason never to say what they think again. And I said, yeah, you're a public agency. Like if you get it wrong, or even if you get it right, you may get sued. That's not a reason not to do your job. And, I'm sure anytime you come out with something and the whole industry thinks that you're wrong, that agency is going to get sued, but you still have to come out with what you think is the guidance. And yeah, so I expected answers. I was very disappointed. Yeah.
And Aaron, how about you? What were you hoping for? And were you too disappointed?
I was hoping that stakeholders would finally be treated like adults. I was hoping that USCIS would behave professionally. Instead, I feel that it was a patronizing exercise at best. I was especially offended by their demeanor. The Cheshire Cat grins that they wore throughout a prepackaged exercise, believing that they were doing something wonderful and that we were to be graced with their presence, I found particularly insulting. And I will say as well, having been on the stakeholder call, the plaintiff's call yesterday afternoon, I'll note as well that the DOJ representative, when he made his comment about, about posting anything, and if we post anything, we'll get sued, I was shocked to see his demeanor. He was indignant and doing his best to hold himself out with some false sense of bravado that I also found particularly insulting. And I wonder, where all of that behavior is coming from. If you set aside the reality that they offer nothing, answered nothing, actually created more problems than they solved, after postponing this event in order to prepare, where is this self-righteousness and this indignation and this lack of professionalism and this patronizing attitude coming from? What's sparking it? I wonder to what extent, if we're ever able to get to the heart of that, we might actually be able to have a conversation like adults.
Greg,
Yes.
you got to go next.
Well, yeah, I mean, within several agencies within USCIS, the attitude seems to be, well, we're just going to get sued anyway. Let's just push it out and let the courts decide. And that becomes an indignant way of responding to the customers that you're tasked with servicing with the money that they pay for you to do a good job. And the expectations are just limited to, did you complete this task? Maybe, right? Like, did you actually move the ball forward? Are you implementing a product? No. Are you talking to the public in a certain way? Like, yes, I'm checking a box, but USCIS is not equipping IPO with the opportunity to have meaningful dialogue. Going back to what we've always said, you don't know who you're talking to. And these people are getting questions without seeing a face, without feeling that they have an obligation to deliver a cogent response, let alone something meaningful. So it's frustrating to see this happen. Within IPO, you would have just, it goes back to the meetings that we would have. You would have leadership getting challenged from their own employees with anonymous questions with cameras turned off. And there's this attitude like, do it this way. There's a lack of collaboration even within the industry, within the agency itself, within the component. So I'm not surprised to see that some of the responses came across the way they did. You know, we need better. We deserve better.
Now, I mean, my impression was that there was a genuine sense that of like, you know, almost pride, like, you know, we're doing well. We did think about this and we're competently presenting information. Now, do you think that that is the feeling on the inside, or do you think it's, you know, kind of plastering over another, you know, felt reality?
Yeah, for me, to a certain extent, I think that Nadine did a good job with her 956K presentation. She came across as a subject matter expert. She got a lot of follow-up questions. I think she did a good job. I think that she probably feels that she did her job presenting the way that these forms are going to look. But then it gets to the other Q&A and things just got lost.
Steve Strnisha, what do you think?
Well, I can't add any different perspective than that. I share the same perspective in terms of the result. I will say on the last point, I think, because you were asked, how do you think they felt they did? And I would guess they felt they did. They presented and addressed the questions exactly the way they planned to, and they coordinated it between all the various folks who were answering questions. It was very coordinated. I would guess that they would come back after that and say, we executed the game plan exactly the way we wanted to do it between the different parties involved. But obviously the result to us was a lack of information, a lack of respect and so forth. I will say I shared some of the optimism early on that when they delayed it, perhaps they were going to really consider some of these things. They had already gotten some initial feedback on some of the things, particularly related to fees and most recently the integrity fee. And there was some thought, well, maybe they'll back off of that. And obviously they did not, and they kind of doubled down at the end of the day. I thought this might be a place where they kind of show what their priorities are and sort of, if you will, pick their fights. And they basically said, no, we're going to fight everything. And to the point of, you know, I think the near-term way to deal with USCIS, unfortunately, is litigation. I mean, you know, fortunately for the ultimate result, they're so wrong on so many of their interpretations that I think litigation will prove effective for those who, you know, step forward on these issues. But it's certainly a less than ideal way to get clarity through litigation. But I think that they're very clear that's you have to fight them to get them to get to where they're supposed to be.
David, do we have to do this? Do we have to fight them and take them to court? I mean, AILA is all about liaising and talking.
Yeah, so
Your preferences.
I generally don't have a lot of optimism when it comes to USCIS and engagements ever since the Ali Mayorkas days that were kind of the heydays of meaningful back and forth engagement. And so I had no reason for optimism except, well, let's say, so on October 2022 was our prior engagement. And that one, if you recall, they spent half the time introducing each other and talking about their backgrounds and everything else, and not talking about the substance for which we were there. And on the heels of that, I think we all felt so frustrated, and Carolyn led the way on our committee. Thank you for writing this really fantastic letter that AILA sent off that said to IPO, can we please have substantive engagements? And here's some examples of what you IPO have done in the past. We want to have dialogue. Can we narrow it down to specific topics so we don't have 101 questions, watering down any opportunity for meaningful discussion? And it was this brilliant letter. And I thought, let's see what happens. And USCIS responded back and they said, thank you, we got your letter. We unfortunately can't have, perhaps the one-on-one engagements that you're looking for because of restrictions on engagement policy. However, we hear you and we think you'll like what's going to happen in the future. And I thought, and then comes the invitation of this most recent engagement that says we will be talking about 3 topics. Boiled down to 3 important things that we're all facing. Like maybe we're onto something here. Maybe the letters have worked. And then they postponed because we heard that maybe they didn't have all the answers. And I thought, yeah, like Lulu said, good, maybe they're thinking about this and they want to substantively address those questions. And then comes the disaster of last week, where I think Aaron is absolutely right. Like it was very disappointing, and I think unprofessional and so scripted and lacking any substantive information other than on K, and I'll give them that was actually helpful, but they ignored 2 other kind of really critical front and center topics. And I think the format that they decided to go with, which is the chat box questions with no opportunity for any follow-up, really, it almost goes back to like a listening session, right? Without any kind of back and forth engagement, it is not an engagement. And so I think we're back to feeling very frustrated and a sense that IPO does not really want to engage.
One question, and I think this is a question for Greg because of his experience within the agency. I mean, do you think that, what we just heard from the folks here is pretty excoriating. And it was in a range, but there was that. Do you think they hear it, or do they just go, they're just complaining and we're never going to make them happy anyway? What do you think?
I'm not sure to what extent they care, and if they did care, what would USCIS do about their voice? I think it comes at a higher level than IPO. I think that there's just culturally just this subdued, don't be an activist, do what you're told. Your engagement is going to be rolled out by your leadership, and you're going to do it, and you're going to show up, and you're going to, what Stephen said, you're going to roll out the game plan, you're going to deliver what you're told to do, and then you're going to get back to work.
I think, Carolyn, in terms of your question, like, do they think they're doing a good job? Or I think they're scared of their shadow, quite frankly. I think they're not equipped to think out the way their decisions will play out in the actual market. And in the absence of their understanding truly the way the program works on the ground, how this decision affects 6 things over here and 10 things over here and implicates, they keep doing it wrong because they don't have the tool set to get it right. That's the real issue. So when they get a tiny bit right, like talking about the K, which by the way was already clarified on their instructions, and they were just basically reading their instructions again. So that's, I think, the issue is they're not equipped. They don't get it. They don't get it, and they they say something, they get sued. It was like, well, we thought that was right. You thought it was right because you don't really understand how it works.
And you're working hard, but in a vacuum, right?
In a
That's
vacuum.
how I feel.
Not working hard, but not smart. And
You know,
there's no one who's like mapping the whole thing out. Like, here's a new legislation. We have to figure out how every aspect of the implementation of K will impact H and I and E, and mapping it out. Should be some huge, Venn diagram or whatever the hell. That's not the way they operate. And so of course they're going to get it wrong. And then we are left with no choice but to do policy by litigation over and over and over.
Aaron, did you want to say something there?
I agree that this is a cultural issue, and that the definition of insanity over and over again, expecting different results, et cetera, et cetera. And this cultural issue, I mean, in my opinion, goes all the way back to the months and years after 9/11, when the Department of Homeland Security was established, and the reason it was established. And Lulu pointed this out when we were up on the Hill, maybe it was just among ourselves, but the reason DHS exists is to keep out the bad guys. And their instinct is to always do that, and default to believing that anybody with whom they are presented is a bad guy. And my guess is if they were left to their own devices and were only given the task of identifying bad guys, they would probably do a pretty good job. The problem is, as Lulu said, they're not equipped to do anything else. There's too much confusion and fear of their own shadow to engage in any other level. And as a consequence, we're faced with people who are proud of what they do when they've done absolutely nothing at all. And conversations have sparked, and I believe are getting a little bit louder, that maybe it's time for somebody to consider pulling certain elements of this process out of DHS and allowing a different agency to tackle them, because Homeland Security is not the place to review the veracity of offering statements in complex economic development projects. They can identify bad guys, presumably. And after that,
Yeah, that's a whole separate and intriguing idea and conversation that's been floating around for a very long time. Is greater participation of commerce. Yes, Suzanne. What do you?
Well, I didn't want to cut you off. I just had a follow-up on the earlier topic. Yeah, just on the sort of in defense of the specific people involved in this call, some context that I have. One is that I was reading through a bunch of internal emails that AIIA got as part of a FOIA request on another topic. But incidentally, as part of these email exchanges, which were copying, like 20 people, and it was going back and forth on approving Alyssa ML's talking points for I believe it was the February 2022 stakeholder engagement, which when those talking points came out, I thought she said absolutely nothing. But from this email exchange, I know this had to go through a whole bunch of people to get reviewed and approved and back and forth. And when you've got that kind of process, what can you possibly say? And with this specific engagement as well, just hearing it, I thought, I'm hearing nothing. Looking at the transcript, I sort of thought maybe they're trying to get a coded message through to us with this, saying as much as they can say. Like when Alyssa Mel says, we like you would like to have meaningful and substantive engagements and appreciate your understanding that EB-5 engagements are subject to certain legal and policy considerations. Maybe that's her saying as loudly as she can, I know that this is not meaningful or substantive engagement. I'm sorry about that. This is the best I can do under my constraints.
Is that like the hostage who's making the videotape of like, I love my captors.
Hand signals.
They're treating me well.
Yes, exactly. And going back to see what little they said about the investment amount in the regional center operations too, I got the impression that this was very heavily workshopped, these 3 sentences that they gave us, to say as much as they could in those 3 sentences.
Well, that's a really good point, right? So when we're talking about substantive, meaningful engagement, it's probably not Chief ML who gets to make call, right? It's
Right.
got to be higher up.
Yes.
And I thought that that was really, so for those of us who are really, really focused on trying to get substantive engagement, I took away, okay, so they're working, they feel encumbered by 3 authorities. One is Section 107 of the Integrity Act, which we knew. Second is is FACA, which we also kind of suspected. And third are these internal protocols, ethical guidelines. So I kind of thought that was affirming in a way. At least now we have the authorities that the agency feels constrained by. And we can help with that. We can provide some analysis to give cover and an interpretation that would allow for engagement. I mean, I think it's pretty clear. The better reading of those authorities would allow for engagements with industry groups and not with particular actors that are specifically enumerated in Section 107, like NCEs, regional centers, and et cetera. But more to come on that.
Carol, can I make
yeah.
one observation?
sure.
So back to, I think, the IPO not wanting to have a meaningful engagement. So the format that they use and not allowing direct questions and follow-up.
Yeah.
To me, that was like super frustrating. That lacked any opportunity to get clarification. And I think what made it even more maddening was during the call, they said, okay, if you want to submit a question, go to the text box and put your question and hit submit. And so whenever they said that, I put my question in there. My question remained there and unanswered for like 48 minutes. And I don't know if anyone noticed, but we have the tape of it. They ended it 10 minutes early.
Right.
Yeah.
So my question was not answered and they ended 10 minutes early. And I know from other EB-5 committee members, AILA EB-5 committee, that their questions had not answered. So is it really, was it really their interest to have questions and engagement and provide answers that weren't pre-scripted? I think the answer is absolutely no. Like this was a closed thing. And I've heard some people grumbling like the whole thing was taped and do they just hit the play button? Like, we watched.
I think it's unanimous. The format did not work at all. It felt less like an engagement than ever because there were no voices from the public.
But ending 10 minutes
hand,
early when there was questions was absolutely just terrible.
Suzanne?
I was just going to say, on the other hand, what I was expecting is that all of IIUSA and all of AIIA, everyone had their fingers on *9 ready to come up with their pre-scripted talking points to express to USCIS. So I can see why, if they got wind, as it seems they did, they were concerned about this concerted, organized comments, that they didn't just want it to be a platform for people to come in and recite their industry organized talking points.
But these industry organizations are important, given the constituents represented. So I think if that were a concern, misplaced.
Yeah.
Should want to hear.
I think, unfortunately, first of all, it was the first time that you could hear and talk, without calling in, right? You used to be able to look at the video, but you'd have to call in on the phone. Now you could do both, but clearly they hadn't figured out how to record that, which is shocking, to tell people at the beginning of a call that it's not going to be recorded and there will be no transcript, unlike every other engagement call. So I think a lot of us were scrambling around to figure out how we could make a recording right then. And I don't even know if they knew technologically how to take calls and respond. Like, they got half of it, but they only got halfway there by the time they had this call. Maybe by the next one, they'll actually know how to record their own call. So part of it, I feel like, I know from what they've said about the lockbox and the lockbox contractor and how they have no control over the receipts, like their technology is not what we're used to in our world at this point. And so even that was just baffling to me, that you would start out a call saying, by the way, we're not recording it. I mean, that is something you should have said on your announcement, so that other people would know they needed to record it if they wanted to have a record.
Yeah, I think
I think even for their 107 argument, it's kind of shocking that they didn't record it, because then people who weren't on the call have no record of it.
Right.
Also, I think they did record it because when I was listening to it after it ended, it started replaying from the beginning.
Oh my God.
And it replayed for about an hour, and I thought I would get my recording the second time that failed the first time, but
Wow.
they did eventually cut it off after about an hour of the replay.
the formatting was a failure.
Yeah.
I think that's even the kindest of listeners would agree.
I think it's absolutely that it was purposeful that they didn't record it. I think to say their technology is bad or they didn't know how to do it, I don't think we can be naive on that stuff. Of course they didn't want it recorded for whatever. You know,
I find it hard to believe, honestly, because surely one would expect that somebody could record it, and indeed, people managed. So I don't know.
They've recorded every other lousy stakeholder call and produced a transcript. So I do think that they just, again, didn't think through like what the reaction would be, what the consequences, especially the 107 that they're constantly throwing up as a shield. We can't talk to anybody because everybody has to know what we're saying. Well, then record your call, and do a transcript.
Yes, Greg.
Yeah, follow on to Rule 107. They said that they fielded and responded to 8,000 customer service inquiries. Where are they? What did you tell people? Only the people who asked the question get the privilege of the answer. Now we've got a Rule 107 violation right there. Why are you answering so many redundant questions? Like 8,000 times, I'm sure you're answering the same question more than once too. This is not the efficiency of the service. So my question is, where's Congress on this? Their constituents deserve to know more. Where's the conversation with Urjadu saying, you're failing us?
Wow, that's a great point.
Don't you think the response back from the email line is, thank you, your case is pending, please look to reported normal processing times, you're still in normal processing time?
There can't be anything.
That was that
substantive about
7,000
it, right?
times. Yes, there's 7,000
exactly.
of the 8.
Copy and paste.
Yeah. All right, we can come back to this, and in fact, we can talk about this all day. Let's hit some of the substantive points. Even if they weren't addressed, we can talk among ourselves because this is important, right? Okay, so the 3 topics again were sustainment, regional center operations, and the Form I-956K, which is brand spanking new. Let's talk about sustainment, shall we? So one of the topics was sustainment, and just because our audience also includes people who are, investors and folks who are not living, breathing, eating this every day, probably living healthier existences than we all. Sustainment. So the issue is this. There is new language in the EB-5 Reform and Integrity Act, RIA, that might suggest that the investment requirement duration is 2 years, minimum of 2 years, which might suggest it doesn't have to be longer than 2 years. And so you can imagine, folks are going to take this potential interpretation and run with it on the private sector side. It seems that this might be the favored interpretation on the agency side, and there is some evidence of this. So let's talk about this. Lulu and Aaron, can I ask you guys to kick this discussion off, because you guys have been very involved in advocacy from the regional center industry perspective, and then I think we can go on from there. There's also, I'll just also add this. It's an instance where we have internal inconsistency from agency communications on this, because the policy manual that does incorporate some updates from RIA flowing down has a new treatment. It incorporates this concept of a minimum of a 2-year investment in Chapter 2. However, in Chapter 5, in removal of conditions section, we still have the old sustainment concept, the duration. It says that investments have to be sustained over the course of the investor's conditional residency period. Footnote 4, still there, defining the sustainment period as the 2 years of conditional residency. So you have one section in the policy manual that says minimum of 2 years. It means maybe after 2 years, you don't have to sustain the investment. And yet, to get your conditions removed under Chapter 5, you've got to sustain for the 2 years of conditional residency. So that is, we're certainly not getting actionable guidance from the policy manual. So Lulu, tell us what's happening. There's been Hill advocacy on this, and just kind of bring folks up to speed on
Sure.
perspective.
So I would like to think we are taking it from the regional center and the investor perspective, because I think a lot of regional centers, a lot of well-respected, long-time regional centers with good track records are very concerned about what kind of deals would be offered to investors that would require just 2 years. And most of us feel they would be likely to be higher risk for investors, which ultimately can bring shame to the whole ecosystem, right? Because the last thing we need is a bunch of promised 2-year deals that never pay or go bust or whatever it is. And come 2026, we're knocking on doors to get our reauthorization. And they're saying, God, you guys screwed it up again. Even though we put all these integrity measures in, you found a way to make a mess. So I'd like to think we're looking at it from the investor point of view, from the regional center point of view, and from the EB-5 ecosystem point of view. In the absence of true guidance, yes, people are going to come in and make it up. And we have a lot of players out there making it up. It's only 2 years, coming at the end of construction. We don't know if any of those things are going to make for an approvable 526E petition. That is a big problem. And that was one of our main concerns in the settlement conference and also on the Hill. In the absence of guidance, the market will fill the vacuum with not necessarily good things. So very important that we get the guidance. Do they have to get it perfectly right? No. Will we sue them if they don't? Maybe. But they have to let people know so investors can be protected, regional centers can do their jobs, what it is that's expected. Now, there's still a regulation on the books. They're going to have to go through the APA process, not something they've even mentioned anywhere. But I think that for us, that's the issue around sustainment.
Mm-hmm.
Nothing in the statute that requires a change says a minimum of 2 years. That to me means it can't be less. We don't know which 2 years. We don't know when the 2 years starts. We don't know, is it after all the money's in? Is it the NCE? It's just too much unknown, and it is causing chaos in the market and for the investors. And understandably, they're saying, oh, 2 years, that's great. I'd like to get my money back in 2 years. You can promise anything. It's whether you perform that will matter ultimately and impact the entire industry down the road.
Suzanne, I kind of feel like you have a finger on the pulse of this issue from an investor's perspective. I'd love to hear your thoughts on this, and then I'd love to hear Greg's thoughts too.
Well, I guess I'll say my thoughts first that I think encapsulate sort of both a regional center and investor perspective, is that both regional center and investors want the pitch that you make to them in order to invest to be true, to be possible. And the pitch at the beginning, you can't tell investors that you're putting money away for an unlimited amount of time over which you have no control and we have no control. It just depends on the immigration process and how much sweet time they take to process your petition, and then how long it takes to get a visa available, which we can't tell you right now. We can't even tell you how your money is going to be used, because you're going to put it in this first project, but then if the time is long enough, we're going to have to put it in another project. Nobody would invest in EB-5 if that's the pitch that you had to give them. But that pitch can be the reality unless we fix some of the issues that address some of the issues that are creating that reality, which is one, all the unpredictable timing issues, but then number two, this issue of the sustainment period. So this is why this is such a issue of concern for investors, because a lot of the risk that they take and the frustration that they have with redeployment is over the investment period. And is it just sort of a time that can be unlimited by the immigration process, or can it be more defined as, okay, it's this predictable time that our issuers can depend on, that we can depend on.
Greg, what's going on in there?
You know, it's interesting because my personal thought is, if you just take the roll back, walk back policy manual for a minute, if we're allowing you to get 2 years of credit as soon as you deploy the funds, we can probably get rid of the 829 processing. If your 526 comes right for adjudicated and you've done your 2 years, then you can upload to Ellis your K1s and you're done. I'm going to give you a 10-year green card right now. Backlog's gone. Now, if processing time comes down to inside 2 years, that's a different story. But is this a question that they're having at USCIS that prevents them from giving us any answers? I don't know. With so many moving parts and perspectives, I can see why they're stuck, because they just are out of touch with what's happening out here.
I just want to keep going to, well, how do we help them? How do we help them get out of this hellish spiral of, of siloed echo chamber vacuum situation? See, it's like weak flow. Has any, UNESCO's no exit. There's got to be a way. I mean, we've got litigation, we've got the hammer for sure, and it will be used. But there's got to be another way. All right.
I think we need another legislative fix, because it isn't fair to investors to have their sustainment based on USCIS's incompetent adjudication times. Basically, that's not fair. On the other hand, do we want people to get their money back and have it floating around the US before their source of funds has even been looked at? I mean, I don't know the answers, but I think the way to do it is to have a maximum time that someone has to wait, after which, USCIS, they get a visa after a certain amount of time. So there's ways to fix it. I don't think talking to them is necessarily going to fix it, because
No, maybe not.
Yeah, but I think there's ways to fix it for the industry that makes more sense than an indefinite time, or a time that is
I think you're
completely
right.
disconnected from their immigration process.
I think we need a legislative fix on this one. I loved this discussion. I feel like we really mapped this out and did it honestly. Regional center operations. Okay, so for me, the fundamental question is, what are we going to do with, okay, so I'd love agreement. Do we feel like we're in a space where we agree what regional centers who want to continue operating need to do? They need to file the 956. They need to file the I-956G. And we have lots of other sort of questions about, well, what about 2022? And how do you count the data collection? And, we've got questions. But basically, a regional center wants to keep going, A, and B, they want to recruit investors under RIA, investors who are filing 526Es. They got to file 956, they got to file the 956G. Is there any dissension on that? Cool. What about regional centers who are not going to recruit new investors filing I-526Es? Do we have clarity on what they're supposed to do?
No.
No, I think we have consensus there as well. What are they supposed to do? Are they supposed to file the 956? Are they supposed to file the 956G? Are they supposed to pay the integrity fee?
So David, I'm glad David's on the phone because he and I heard this differently on the call, but I mean, I was happy to hear them even use the phrase winding down regional centers because we've been pushing that phrase on them since the litigation, that they have to take into account what happens to these regional centers who want to support their investors. They don't want to be terminated. They want to be able to support their investors through the process, but they're not going to be doing projects under RIA. And I was glad to hear them use the word and for them to say we're still thinking about it. And the truth is, they haven't given us any guidance on the 956 and the 956G. I mean, a lot of us filed our 956s, but technically, even if you're going under RIA, you don't have to have filed it, right? Because they didn't change that. And, you know, we could argue about 22 or 23. I agree that they probably got that wrong, but who cares at this point. But, and with respect to the integrity fees, I think they got that wrong for everybody. But most of us continuing, you know, we're not going to argue about that at this point. I thought what they meant when they said, we don't know what we're doing with winding down regional centers, that included, they don't know what they're going to do about integrity fees. But David, you heard it a different way.
Yeah, I did. So I think there was two parts of the engagement. So early on, they said, yes, one of our three topics is wind downs, but we'll just let you know we haven't made any decisions. We're still thinking about it. And then they moved on and they answered K questions and other questions. And then kind of in the last 20 minutes or so, there was a question that said, do all regional centers, including those pre-RIA regional centers, do they have to pay the annual integrity fee? And that was the question. And the IPO representative said, oh, I'll take that. That's an easy one. The answer is yes. Next question, and moved on. So I think that's entirely different than how they're treating wind downs. I think they haven't figured out how to do wind downs, but I think they think no matter what, everybody, pre-RA and those who applied under RA, all have to pay the integrity fee. And my question that wasn't asked, that wasn't answered or wasn't raised was how did you come to that decision when the RA language is super clear, and because it says that the integrity fee is only payable by those entities designated under subparagraph E, and that there's only two references to subparagraph E, that one, integrity fee, and also filing the G annual report and paying that fee. It says under subsection E. So my question was, well, you just said that's an easy one, and yes, but how did you get that? You know, they didn't take my question and they didn't answer it, but they think it's an easy one. So yeah, I guess Lulu and I think differently about this, that, you know, she's not sure that regional centers that are winding down have to pay this. And my take from the engagement was they haven't figured out what to do with winding down regional centers, but no matter what, every regional center has to pay this. That was my take of it.
Well, I'm actually surprised that people are not feeling more emboldened by what I think is a natural reading in this from the settlement agreement, that regional centers that don't intend to continue to operate under RIA and have new investors under RIA are not required to seek designation under RIA. To me, that's logical, it's sensible, and that's how I read the settlement agreement. And so, and in that same section of the settlement agreement, it says investors of those regional centers will continue to be processed, which is also consistent with subparagraph S, arguably, new subparagraph S, covering grandfathered investors. So I'm actually kind of surprised. I mean, yes, we don't have absolute clarity, but I am actually a bit surprised at the level of hand-wringing and confusion about what retiring regional centers need to do and not do. And if my reading, humbly submitted, is the better reading, And if it's adopted ultimately, then those regional centers that are retiring and not required to file the 956 or the 956G to continue to have their investors be protected and processed, ought not pay the integrity fee either. It's sort of logically consistent. So
I agree. I agree. I think the settlement dictates that answer. But we'll see. I mean, they are being sued, right? About the integrity fees. Because it doesn't make sense. And when we had those conversations, the idea was not only do they not have to file the 956, but their investors and their investors' applications will be processed, but no investor would have their petition denied solely because their regional center had not filed a 956. Which kind of means the regional center wouldn't be terminated either, right? But now under the integrity fees, they said they have to terminate them. So the stakes went up a little bit, you know, so it's very confusing. It's a little confusing.
It's the termination, and I don't want to get too much into the weeds, but to me, I think that the technical issue is whether those winding down regional centers will be terminated, because termination has these other technical consequences under RIA. So I think that's the one that folks need to be really, really careful about.
Carolyn, one thing I wanted to mention is, you know, AILA and IIUSA sent in a joint letter talking about the integrity fees. And I think it was our position that, frankly, nobody at this point has to pay the integrity fee, because the integrity fee language says only those who are designated under subsection E. So I challenge any regional center or the service to provide a designation letter showing that any regional center has been approved as a designated E entity.
At least for the fiscal year 2023, because some have now been approved, but not by that September 30th deadline of 2022, right? So for this year.
So if you are a winding down regional center, you're not. If you are a pre-RA regional center that filed the 956 or other forms, right, you're still not designated E until they send you your designation letter. And if you're a new regional center and you filed under RAA, I challenge you to show me a new regional center that's been approved under RAA. So again, I have not heard anyone is approved as a new RA regional center yet.
Well, we have been, and there are a bunch of people, but not in time for us to have to pay the integrity fees for the 2023 fiscal year. But right before the stakeholder call, they approved a whole bunch of 956 petitions.
Okay, but still, right, that's the question is, have you been approved or not been approved? And unless they got that letter, you're not approved, in which case you're not subject to the integrity fee.
I agree.
mean, we wrote this long letter, and I guess the frustrating part about this engagement is, and here's a chance to talk about it, and they just said everyone's got to pay. Right? I mean, holy cow, crazy.
You're right. You're totally right about that. Because that letter had analysis, right? Had a position. We deserve more.
Yeah.
All right, regional center operations. Okay, so before we leave regional center operations, I just want to say, folks, including the agency, if you're listening, please read the comments to your 2017 Advanced Notice of Proposed Rulemaking, ANPRM. AILA submitted an incredibly thoughtful 25 page response to your thoughtful questions, agency, about regional center operations. How should regional centers best oversee themselves and monitor their projects? How should we define promoting economic growth? How should we define material change? Loved that. And we gave you pages and pages of heartfelt thoughts on material change analysis. great questions like, you can see what they're struggling with. Should exemplars time out? What's the, should failure to maintain approved exemplars be a reason for terminating the approved exemplar? And if we terminate the exemplar, what should the impact be on the regional center? These were really good, thoughtful questions. And to me, it indicated that the agency is looking for objective markers on adjudication points. When should we take action? When should we terminate? When should we deem this activity affecting a project to have some consequence on the associated investors? Great questions, great answers. I commend everyone to look at the ANPRM and ALS comments again.
Yeah, so Carolyn, on regional center operations, I remember some of the questions that the service wrote. They said, we want to hear what the industry is doing or thinks about regional center operations compliance. How are you monitoring lawful source of funds and your investors? Give us examples, like how are you doing it? How are you keeping records? So when they do a site visit, there's some standards, because they want to know, because I don't think they did know. Right.
Yeah.
This was like a really great opportunity. We thought, wow, they care and they really want to find out what the industry is thinking and what are they doing, and maybe we can learn from it. And it's never gone anywhere. Yeah,
and we should actually have a whole session on the ANPRM and those questions. Okay, so 956K. I think the biggest question is, and I do want to leave it just a few minutes for questions. The biggest question is definitions. We heard again and again, you got to file. Okay, who has to file? Who's a promoter? Who's a direct promoter? Who's a third-party promoter? Who's a migration agent? I think that's the biggest question from the private sector side.
I don't think there's confusion, Carolyn, about that. I don't see why everyone's so confused.
Yeah.
Yeah, I really don't. I mean, if you're promoting an EB-5 project to investors, you're a promoter. If you're a regional center, NCE, affiliated JC, or issuer, thankfully they clarified, because you're filing an F and a 956, you don't have to file the K. That's the biggest thing that came out of it for regional centers, which was in their comments matrix in response to our comments to forms, but most people can't find the comments matrix. So they said it out loud on this call so people can stop fretting, because there was some fretting going on in the industry. So that's great news. And the other good thing that came out is, no, your employees that, put up your marketing booth and answer the phone, and no, they do not have to register. Employees that are promoting, selling securities, essentially, just like in our broker-dealer context, a representative would do. The receptionist doesn't have to be a registered rep, but the person selling does. So I felt like they clarified it as much as it can be clarified. We also know a migration agent is someone who helps people move to another place, as opposed to necessarily promote the actual. So I think people are overthinking it at this point. If you're selling, you register. If you're promoting EB-5 projects, you register. It doesn't matter which box you check, really.
Okay.
That's my take. Is like, and they're not going to get it. We begged them for definitions. They haven't given us any. They've claimed it's because it's not in the legislation. That hasn't stopped them in the past from making up definitions. But in this instance, they didn't want to. And the Securities Roundtable gave them suggestions based on SEC stuff. They're not interested.
Yeah.
They're promoting a project, unless you're an NCE, that categories which they exempted, you better register. I think that's my take.
We do have just a couple of questions, and folks, we are almost at the top of the hour, but feel free to send in questions, because we might still respond to them after the event. Somebody said Suzanne is spot on. I don't know about which comment, but
how about her note, open letter to Kevin, what's his name? That was spot on. Thank you for that, Suzanne. Yay.
I've got to read that. I've been savoring.
You have to read it. You do.
Okay, I will. From the time spent recently on Capitol Hill, the general consensus was to push, yes, the letter. It was the letter. From the time spent recently on Capitol Hill, the general consensus was to push hard to have a joint bipartisan letter to Congress, DHS, other to have some advisory oversight committee to monitor and better manage USCIS activities related to EB-5. Thoughts? Right?
Thoughts on, thoughts
Yeah.
on what?
Somebody is soliciting our thoughts on the idea, I guess, to compose some sort of oversight committee to monitor USCIS's RIA implementation.
So on there, when IIUSA was on the Hill this past week, we had two teams. One was focused on the House of Representatives and the other was focused on the Senate. My understanding, I was on the Senate side during this time with Lulu and Adam Green. My understanding, and listening to the folks who debrief from the House side, our conversations with each member all started off the same way. It was essentially, thank you very much. We were meeting, in many instances, meeting with co-sponsors of the bill on the House side and then new members as well. But it was generally, thank you very much for the reauthorization. We got most of what we wanted, just about everything that we needed. Industry is rising to the occasion. And there are a few bumps in the road. And the response back from congressional staff at that point was almost uniform. What do you mean bumps in the road? What's the problem? Is there an issue with implementation? Which obviously, this being on the 26th and 27th, and we all just haven't come off of the debacle of the 25th, we were able to just, vomit out all kinds of reasons of issues that we had seen, problems that persist, attitudes that insult. And I think on the House side, there was a consensus among congressional staff and the folks who were meeting with them that a letter be drafted specifically to be signed by the members of the House who were co-sponsors of the reauthorization bill that articulated the issues that the industry is seeing in implementation, all of them, a list of grievances, if you will, that articulated very clearly, here are the bumps in the road. On the Senate side, we didn't talk as much about the possibility of a letter, although we are 100% for it. I think it's a great idea and a wonderful starting point for perhaps a new conversation between the Department of Homeland Security, Leg Affairs, at least, and the Hill. On the Senate side, we talked more about the possibility of establishing a new advisory committee, perhaps via legislation, that would require conversations with DHS about operational issues pertaining to the regional center program. If they were required legislatively to have such a conversation on a routine basis and report back to Congress,
Yeah.
would that make a difference?
Oh my God, yes. Because then 107, that goes away or is overridden or is worked around. I like it. I like it. I like it.
Well, IIUSA is making progress towards that actual goal. There'll be more to be said about that in the coming weeks, I'm sure. And I hope that you're right. I hope that you're right that it will make a difference.
I feel very strongly about this. Yes, 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 yes. This
Yeah,
is-
I think it highlights more, Suzanne's example with David's, comment too, like is the chief of IPO being held hostage and trying to send a message like, go above us because I need help.
Mhm,
Come rescue me.
mhm, 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 mhm.
I believe that so much of what we've spoken about is rooted in issues within the administration, within IPO's culture. And to change that, and therefore to change the conversation, I believe we need one of two things, if not both. One is a change in perspective among DHS leadership. And the other is creative solutions that in all likelihood have their roots in legislation. And perhaps this initial foray, and establishing an advisory committee is a step in that direction.
Your mouth.
To God's ears.
Years. Yes, 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 yes. Fabulous note to end on. My goodness. Steve Strnisha, David Morris, Greg Sheehan, Suzanne Lazicki, Lulu Gordon, and Aaron Grau. Thank you. Thank you. Thank you. Thank you. We are very well served by you.
Carolyn, great job. Great job, everyone. Thank
Great
you.
job, Carolyn.
you so
Thank
much.
you.
Thank you. Speak soon. Bye, everyone.
Bye.